Tēnā koutou katoa. We're delighted to be here and very proud to have been asked and to be representing Chapman Tripp in talking about this opinion. I should say at the outset that the opinion is a big team effort. It's written by my wonderfully talented colleague Nicola and myself, but it's been contributed to by a vast range of people within and without Chapman Tripp. And I'm very pleased to see our Chief Executive Partner Nick Wells here and Penny Sheeran, who's on the Aotearoa Circle leadership team. And they're just two of the people who've had a look at the opinion on the way. We've also had comments from Matt and from Sir Jonathan Porritt and others. But all of the errors, all of the bits of reasoning remain our own responsibility. But in keeping with that collaborative spirit, we're going to do a bit of a double act in talking about the opinion, and we're mindful of both time and an audience that is likely to be within the choir that we're preaching to rather than outside it. So we're going to focus on the law really only where we have to introduce what we're talking about, and we're going to really try and concentrate on practicalities and what we can take out of this. So when Nicola gets going, you'll see me scooting around the room handing out our one-page handout, which is the thing we allowed ourselves to print. The opinion is quite a lot larger than that, but that will at least give you something that you can take away to try and get your head around. And I think I'll say at the outset that the opinion is really a sort of exercise in applied common sense. By applied common sense, we mean that what we're saying is not hugely controversial. What we're saying is that when you think about what you're doing with climate change and how climate change works, if you see it through a financial lens, then all of the conclusions really fall out and become pretty clear. It's a financial risk that has to be taken into account just like any other financial risk. What we think it's helpful to do is to spell out why that is, what that means, and what the steps that could practically be taken to do something about that are. And as we go through the discussion, we'll talk about these things in order, and we'll also get to some of the questions and thoughts that Matt was raising about that sort of slide between prohibition to permission to requirement that fiduciary duties are sort of starting to undergo. So this is the question that we were asked to answer. To what extent, if at all, are New Zealand company directors and managed scheme providers, and that's just our fancy FMCA term for fund managers, permitted or required to take account of climate change considerations in decision making? And what we found right at the outset as we were thinking about this is that while the question is the same for directors and scheme managers, and the analysis is not totally different, the two factors that go into it work differently. So for company directors, the most important consideration is the duty, which isn't strictly a fiduciary duty, to act with due diligence, care and skill. And it's less important, but not totally irrelevant, the duty to act in accordance with best interests and for proper purposes. And the reason for that is that where you're running a company, the concept of what a company's best interests in is malleable. Company directors are given a large amount of discretion and latitude by courts to decide what is in the best interest, and it's actually a self-judging test anyway. So you'd have to show that a director couldn't possibly have believed that something was in their best interest in order to show that that test isn't met. So that's not where the real work is done for directors. The real work is done where you're looking at the duty of diligence, care and skill. And if you just think back to the GFC cases and what the courts had to say about that, you can see the rising tide of expertise required by directors, the inquiring mind they have to have, the amount of effort they have to put into understanding what's in front of them. So that's that context. When you think about fund managers, it's the other way around. That they do have a duty to exercise reasonable care and skill, that's true, but they've got an even more exacting, an even more clinical duty to be blinkered in what they do, so that they act only for the best interests of the fund beneficiaries, which is usually the financial best interest, which means that everything else is an extraneous consideration. Now that might be something that down the track, Matt's project might want to change, but At the moment, that's where the law sits. What's changed, though, moving from prohibition to requirement, is that climate change now sits on the other side of that scale. It's not an extraneous non-financial consideration. It's a financial and quite possibly a material financial consideration. So the way our analysis comes out then is, are you permitted to take into account of climate change? Well, yes, as a potentially relevant financial factor in both cases. That's not controversial. Are you required to do so? Well, the answer is yes as well. And the analysis is only slightly different. For directors, the reason the answer is yes is because that test of reasonable skill and care really is a balancing test, taking into account how foreseeable a risk is, how material it is, how big an impact it would have if you didn't take it into account, how easy it is to take into account, what expertise is available. Basically, what would a reasonable director do? And that's how that's put together. For a fund manager, it's more cut and dried. Where something becomes a material financial risk, it's not a matter of choice, it's not a matter of discretion, it's not a matter of balancing. It's a question of obligation, because your duty, your fiduciary duty to act in the best interests of the beneficiaries means you have to be across the material financial risks, otherwise you just can't do your job. So we will come, and really what Nicola and I are going to be talking about is what this really means, and so we'll spell this out in terms of the tests that you might take and how you might go through it. But basically what it means on both sides of the spectrum is that there needs to be some real care and attention paid to how you think about climate change. And in a nutshell, that means being reasonably sophisticated about thinking about climate change as a potential financial risk. And that's all I'll say until Nicola has spelled out some more of the background.
Kia ora koutou, thank you, Daniel. It's a privilege to have been working on this opinion, and what we want to do is just take you through a little bit of the background and context, because that is really critical to working out what a reasonable director would do, or what a reasonable fund manager would do, and what the courts are going to look at if they're assessing a claim that a director has not acted properly in terms of considering climate change. So I'm not going to spend time on the science because we have an excellent speaker from NIWA coming right after me, so I'm going to dive straight into the regulatory response to climate change. And again, this room is very well aware of the international and the domestic regulatory response to climate change, the impact of the Paris Agreement, the impact particularly of the nationally determined contributions that each country is now having to publish in terms of what it is going to do to be meeting its obligations under the Paris Agreement. And in New Zealand, how that is playing out in terms of the zero carbon bill, the ETS reform, the oil and gas policy that's coming from the government at the moment. That's the international domestic policy and regulatory context. Something else that is really important and comes through the work that Matt was touching on before, particularly in the UK and Europe, is the increasing focus on climate-related financial risk and disclosure of that. Most of you in the room will be aware of the TCFD recommendations, the Task Force on Climate-Related Financial Disclosures recommendations, came out about 2 years ago now, and are getting a lot of increasing amounts of traction, particularly the UK, the Europe, and the US. We're seeing this coming to New Zealand as well, and that's why it's important to have a look at this, because it is forming part of the relevant background for what directors and fund managers need to be aware of. For those who haven't come across this in as much detail, what the task force essentially said, and this was a G20-led task force, was that organisations should be disclosing material risks from climate change in their annual filings, as they would do any other material risk. And that isn't necessarily a surprising outcome to come to, but it is making a lot of people think, well, what are the material climate-related financial risks to our business? Where do they come from? And those split down into, as shown on Matt's slide, the physical risks and then the transition risks. And those transition risks are the ones that are less obvious. They're the regulatory changes, the potential litigation, the consumer preferences, the market changes, the changes from downstream market and suppliers, etc. What the TCFD has said is you need to be disclosing your governance around these kinds of risks, your risk management in both cases, regardless of materiality, and then your strategy in terms of dealing with climate risk and the metrics and targets that you're using within your business, but where the issues are material. And just in 2019, they've released a really excellent report showing the take-up that the TCFD is getting. And just to pull it right back to New Zealand for a second, the latest we're seeing in New Zealand is the government response, which came out in August this year, to the Productivity Commission's Low Emissions Economy report. And in that report, there were 2 recommendations that were specifically on TCFD. And the government has stated that it is currently their view that listed issuers must make climate-related disclosures. And MB is working on this at the moment in terms of thinking about the policy and how it's going to play out. And I'm privileged to have people from MB in the audience as well. So this is certainly an area which has had a lot of traction in the UK, a lot of traction in Europe, very detailed rules and recommendations coming out, particularly from Europe, on what this means. And we're really seeing that coming to New Zealand, if not right now, in the next sort of 2 to 3 years. So that's the disclosure context, and then of course the corporate context, which all of you are very well familiar with. We've got a huge focus on climate-related financial risk coming from the investment community. We've got shareholder action, a lot of shareholders resolutions being filed in the US and the UK around disclosure of climate risk and climate strategy from business. Litigation, we're now seeing businesses being affected in 2 main ways from litigation, either named directly as defendants, and we're seeing the start of that in New Zealand, or being affected by challenges against what the government is doing. So judicially reviewing major project approvals, etc., and seeing the hold-up from that. And there have been some big decisions in Australia recently where decisions are being overturned, approvals are being overturned for new projects because of failure to sufficiently consider climate change and emissions. So that is important context that we have used in the opinion to reach the view we have that this is an issue that a reasonable director now needs to take care of and to be thinking about. And that has changed from 5-10 years ago because of these contextual factors. And where we get to, as Daniel said, is that directors must, at a minimum, look at the risks specific to their company and identify what they are. And this is something that at the next board meeting, for boards that haven't thought about this, and some have really been engaged on this and others less so, that's the question you want to be asking. What are the particular risks from climate to our business? Are they physical or are they transition-based? And are we sufficiently managing them like we would do any other potentially material financial risk? And once you work through the assessment and deciding whether to take action, are you then required to be disclosing any of this? And that, of course, depends on your status and type of company, etc. But that's the next step. And the good news in all of this is that a lot of this can be managed in terms of conventional risk management strategies. It's a matter of bringing in the climate risks into the way you would manage any of these other risks. So it's not necessarily a scary or new proposition. It's just a matter of getting people's heads around adding this in to the task that boards are already doing. So as Daniel said, and we're not going to go deep into the law today at all, but the key things that a director would need to do in order to be satisfying their duty of care, which is the main way this is going to come up in the courts. And it's not unlikely that someone's going to have a go at this type of litigation against directors in the next 5 years or so, is a director needs to be bringing this informed, independent judgment, an inquiring mind, understanding, asking questions. And the post-GFC cases that Daniel referred to are really asking, are directors looking at risk management and overall strategy as well as the sort of more traditional financial, operational, etc. Factors? And if you can show that you've been thinking through these issues in a sensible way with appropriate advice, making sure you're keeping informed, then a court's going to be reluctant to criticise individual directors for the positions they're taking. But if you're not showing that a proper process has been worked through, that's where I think directors, may come into trouble. And as the materiality of the risk increases, and that will be very context dependent, fact dependent for the particular business, then of course it becomes more unreasonable not to have considered it and then not to have acted in some kind of response. So that brings me through to risk management. These are some of the things that you can immediately start thinking need to be happening for boards: periodic briefings, ensuring you've got the right skills and experience, ensuring you've got the right independent expert advice, and taking concrete steps. I'm not going to spend any time on this. This is the other duty that Daniel referred to. So legally, the opinion goes through these two duties for directors, the reasonable care and the best interest. And as Daniel said, look, best interest is going to be less likely to be litigated. We think the reasonable care issue is going to be where the focus really goes on this. Best interest also runs into the ongoing debate as to what are the best interests of the company and how do you assess those and over what time period do you assess those. New Zealand generally recognises that the best interests of the shareholders, of course, are the best interests of the company. But there's more and more debate, and a lot of you will be very familiar with the increasing debate around the role of stakeholders and the importance of stakeholders. So sort of watch the space on how the courts treat that. And then finally, disclosure. The main point here is that if you have a material financial risk from a climate-related issue, whether it's physical or transitional, this is already something that should be being disclosed, and companies are disclosing this, whether it's in annual reports or ongoing disclosure. But the thing to watch is what is the government going to do to implement these TCFD recommendations, and I think the disclosure is going to get more prescriptive in terms of what you're going to need to disclose. There's going to be more detail required. So immediately for boards, I think, as we've already said, the next agenda item needs to go through this basic assessment for the particular company to see what the particular risks are. Make sure you've got the right expertise, make sure you've got the reporting and disclosure sorted. And I've just got 3 final slides which have a number of really useful questions that boards can be asking in their next meetings. And this is sourced, there's some fantastic resources out there for directors that have been put together this is World Economic Forum, the Commonwealth Climate Law Initiative, who have been doing extensive amounts of work on this. But if you just look at these issues, have you had a briefing on the identification of these risks? Have you critically reviewed whether your advisors are the right ones to be advised? Have you missed out advice on potential litigation or regulatory risk and you're only looking at stranded assets or physical risk, for example? Where does the operational responsibility for this reside within management? Standing declarations, they've D&O insurance. Has this been updated with this lens in mind? When you get into strategy, financial planning and risk management, the second one, how does our exposure differ under different scenarios? How are we determining materiality? And that's, of course, important for disclosure. What are our strategies for the potential market shifts, M&A, capital allocation in particular? How are we engaging with government on this issue? Are we engaging in the TCFD development of the law that's happening? Because I think that would be really useful. Industry bodies, and then making sure, are our investors focused on this, and are we keeping in step with what they're really interested in? And then disclosure, are we high risk? How is this reflected in all of these different reports that we're required to produce? Forward-looking statements in relation to climate-related risks, are they supported by evidence? And I think an important point right down the bottom is, are we being consistent across all sides? Is the right talking to the left, not only at the board level, but as the reporting that's going into some of the sustainability organisations, is that stacking up with what we're also reporting in terms of annual reports, etc., and marketing and talking to stakeholders? So it seems a really obvious point in terms of directors need to be thinking about this and working out the risk to their business, but it's useful to break it down into these particular questions and think, actually, is this something that we've sufficiently engaged on, or is there a bit more we could do? Those are the resources I was mentioning.
Thank you. So now we'll look just very quickly at scheme managers. So I've already set out that these are the 2 main duties, but it's the first one that you're focused on, and that's the legacy of trust law that is sort of hardwired into both the existing Trust Act, the new Trust Act that's coming in, and the relevant features of the FMCA. So wherever you look, and there'll be some subtle legal debates in the future about what certain differences of expression might mean, but the core principle is the same, that when you're managing someone else's money, then you have fiduciary duties not to indulge your own moral scruples as you go about doing it. And it's really unpacking and teasing out what that means that this whole discussion is about. And that really came to a head in a famous case, which is the only case that we were going to talk about here, because it's the only case you really need to know in this area. Arthur Scargill, who is a very well-known unionist of the Coal Miners Union in the UK, still litigating, still going strong, had his first foray into the High Court, where he sacked his lawyer 2 days before the hearing and argued the case himself on a debate over a very massive pension scheme that existed for the coal workers' pension fund. And they had a board of trustees. They had 5 people who were externally appointed and 5 people appointed by the union, no deadlock mechanism. And they've been bickering for years over whether the plan by the unionists to stop overseas investment and to stop investment in oil was okay or not, or whether it would breach fiduciary duties not to invest in these assets because they were more lucrative. And Scargill lost that case. And that case has become renowned throughout the common law world as the case that tells you, so goes the sort of aphorism, that you must focus on profit maximisation. It's actually a really great case when you read it, and Sir Robert McGarry does a very good and careful job in his judgment of explaining that this is really just an application of the best interest test, and it's about the rule of not indulging your moral scruples at someone else's expense and having a single agenda that isn't affected by ulterior motives. But its message has been diluted over the years by people who haven't read it, and gradually, sometimes this happens with cases, they get to be remembered for something that is a shadow of the depth of reasoning that they're really about. What this case was really about was just the idea that best interests is the same as proper purposes, and the best interests of a fund are usually the financial interests of the members. So that's what you have to focus on. But the case is not really authority. In fact, we say it's not authority at all, for the idea that what that means is you must go out when you're managing a fund and profit maximize by buying the most expensive short-term returning stocks, and that you'll be tested on the outcome retrospectively as to whether you bought the stocks that were returning the highest yield at the day. We're in a world of modern portfolio theory, and many people in this room, including Matt, know that much better than I do. But courts realise this too. And what they realise is that the job of acting in the best financial interests of members is going to be a sophisticated job of having a diversified portfolio, the objective of which is to secure risk-adjusted returns over the period of the fund, not just tomorrow, and there'll be a balance between value and income, and there'll be a number of different factors taken into account. So the simplistic idea that what the law has required is to go and buy the highest stocks was never true. What that means when you start to unpack it is that for climate change, it's not a very difficult analysis. It's just another financial risk that when it becomes to be a material financial risk, say because stocks that are well priced now are going to be differently priced in the future, stocks that are returning well now are going to return differently in the future, then you're going to need, in order to have a well-balanced, effective portfolio that gives you the best realistic long-term return, something more sophisticated. So what we say about that is that scheme managers have to do, as I'm sure most of them in New Zealand already do, take a lot of care assessing the overall objectives of what the fund is about, have an in-depth sense as to whether its idea is to grow as much value as they can immediately or to preserve risk-adjusted value over a long period, and then work out, as against that statement of purpose, what the real role of climate change is going to play. And I imagine the touch point is that the longer the fund is in existence for, the more climate change is going to be important. That last bullet point's important. That's a restatement, effectively, of the Cowan and Scargill test by the English and Welsh Law Commission, which we endorse in the opinion. We think the idea of securing, as a sort of baseline epithet, the best realistic return over the long term is in fact what the case was always trying to say and is best understood as. We mention, just for the future, something very briefly about non-financial factors. We don't get into it in the opinion because we say climate change is a financial factor, but where to look about what might happen with non-financial factors is really that UNEP report that Matt refers to. There was an early version of that in 2005 that I worked on when I was at Freshfields in London. There was a later version in 2009, and there's one in 2015. And Matt is quite right to see the evolution of where fiduciary duties are heading. One thing just to bear in mind of where the law might be tested in the future is the so-called tie-break rule. What happens if you have two investments that are both equally palatable to your portfolio? One is ethical, one is not ethical. Can you pick the ethical one? Some people purport to have a problem with this. We don't think a New Zealand court would find that a very hard decision, but we don't definitively opine on it either. The overall implications are really just what I was spelling out earlier. So the idea of going one layer below being generally aware of climate change as a headline issue and thinking through how it really works. What are the nationally determined contributions of the country? What exactly are companies that you're thinking about investing doing? How is climate change going to affect them, not just directly, but indirectly? And really, the whole opinion can be boiled down, if there's anything profound in it, to the idea that what might not be concentrated on enough by both directors and fund managers are indirect transition risks. Everyone knows that if you have a stranded asset, it's not a good investment. But what about if your customer base is going to gradually migrate to a competitor over time because your product is going to be viewed through the lens of sustainability, and that's not what your strategy is. So it's thinking about those second-order questions and making sure that everything you're doing fits with the statement of investment purpose and objectives, which is required under the FMCA. And then finally, there's a bunch of resources, just like for directors, for fund managers there. I won't spell them out now, but we can come and talk to you at the end about them if that's of interest. Thank you.